Imagine handing over like $500,000, right? You finally hold the keys to your new home, and you feel like the undisputed king of the castle.
Oh, yeah, it's the ultimate dream for most people.
Right. You own the dirt, you own the walls, it is just your absolute domain. But then imagine finding out, say, a week later, that a complete stranger legally has the right to just bulldoze your driveway.
Because of some piece of paper signed back in 1942, probably.
Exactly. Suddenly your whole kingdom feels a lot like, well, a fragile house of cards.
Yeah.
So today, we are looking at those invisible strings attached to the ground beneath your feet.
And that piece of paper you mentioned, it might be an old utility easement or maybe a forgotten zoning restriction. And discovering it too late is honestly one of the most common and devastating traps in the whole property market.
Yeah, it really is. So welcome to today's deep dive. We are taking that feeling of holding the keys, that mix of massive excitement and sudden, overwhelming confusion, and we are clearing it up. We're diving into the mechanics of property control through this book called Real Estate Law Essentials. Navigate Transactions, Avoid Pitfalls, and Seize Opportunities by Willem Tait.
It's a great read. But before we jump into the mechanics, we should probably lay down our own boundary line here.
Right, the disclaimer.
Yes. So while we are exploring some really fascinating legal and real estate strategies today, this deep dive does not constitute formal legal advice. You always want to check your local regulations and, consult with qualified professionals before making any big business or property decisions.
For sure. Keep your local experts on speed dial. But what is incredibly useful about Tait's book is that, well, even though he uses the U.S. property market as his legal framework, the underlying logic, the mechanisms of control and transfer, they really apply globally.
They absolutely do.
The mission of this deep dive is to take this really complex, jargon-heavy maze of property law and transform it into an accessible toolkit for you. We want to uncover how understanding the actual machinery of the law protects your rights, stops you from making wildly expensive mistakes, and empowers you to seize opportunities.
I mean, the law is often viewed as just this tedious set of restrictions, right? But Tait's premise is that the law is actually the operating system of the entire real estate market.
The operating system, I like that.
Yeah, if you don't know the code, you basically can't run the software.
And before you can buy, sell, or even manage a property, you really have to understand what it actually means to, own something in the first place.
Right, which is not as simple as it sounds.
Exactly. We're moving from that overarching premise straight down to the literal bedrock.
Let's talk about ownership rights, because reading through these sources, I realized ownership isn't just a single switch that you flip on or off. No, it is much more like a bundle of sticks. That's the classic legal analogy. Each stick represents a specific right. So the right to occupy, the right to sell, the right to lease, the right to alter the property.
A bundle of sticks.
Right. And in the book, Tait contrasts two main categories of these bundles: freehold estates and the leasehold estates.
Okay, so let's unpack this a bit. Freehold sounds like that king of the castle scenario we opened with, right? Like the absolute maximum number of sticks in the bundle.
It is. It's the highest level of control recognized by law. This includes what's called fee simple ownership, which is what most people think of when they buy a house.
Meaning I own it forever.
Basically, yeah. You own the land and the buildings on it indefinitely, and you can pass it down to your heirs. But it also includes things like life estates.
Wait, what's a life estate?
So that's where you hold that bundle of rights for the duration of your life. But the exact moment you pass away, the property automatically transfers to a designated remainder person. It completely bypasses your will.
Oh, wow. Okay, so that's freehold. Then you contrast that with a leasehold estate, where you are basically just renting a few sticks from the owner's bundle for a set amount of time.
Exactly. You have the right to occupy and use the space like in a commercial storefront or an apartment, but you obviously can't sell it, and your use is dictated entirely by a lease agreement.
Makes sense.
Yeah.
But even if you secure that ultimate freehold, fee simple ownership, the landscape of how you acquire it has shifted massively, hasn't it?
Oh, completely. Historically, the entire real estate market operated on this doctrine of caveat emptor.
Which translates to let the buyer beware.
Right. Meaning, if you bought a gorgeous estate and a month later the foundation sank into a hidden swamp.
The courts would essentially tell me, tough luck, you should have hired a swamp inspector.
Exactly. The burden was entirely on you to verify every single physical and legal aspect of the property before handing over the money.
That sounds incredibly stressful.
It was. But Tait details how modern statutory regulations have dramatically evolved to protect consumers. We have moved from that system of buyer beware to a system of mandatory disclosure.
Meaning sellers have to tell you what's wrong.
Yes. Sellers are now legally obligated to reveal known material defects, like a leaky roof or a history of flooding.
And it goes deeper than just the physical structure too, right? I
Yeah.
mean, we see major statutory frameworks stepping in to regulate the transaction itself, like the Fair Housing Act.
Exactly.
You can't just refuse to sell your property to someone based on race, religion, or gender. The government has intervened to enforce fundamental fairness in the market.
Which brings us right back to your opening scenario with the bulldozed driveway.
Oh, right.
That government intervention means that even with fee simple ownership, your control is never truly absolute.
That is the realization I had while processing this material. It sounds like I own the canvas and I own the easel, but the government tells me what colors I am legally allowed to paint with.
Well, what's fascinating here is that analogy hits the nail on the head. You own the canvas, sure, but the broader community gets a veto on the final painting.
Right.
And that introduces the hidden limits of ownership zoning laws and easements. Zoning laws are established at the local municipal level, and their mechanism is essentially to carve a city up into distinct use categories.
Like residential, commercial, industrial, agricultural.
Exactly.
Which is to prevent someone from, say, buying the empty lot next to my house and building a 24-hour toxic chemical refinery.
Precisely. The whole logic behind zoning is to protect property values and public health. You just cannot mix incompatible land uses without destroying the utility of the community.
Makes total sense.
Mm-hmm.
But wait, if zoning handles the broad public limits on what I can build, what stops my neighbor from just running a drainage pipe right through the middle of my backyard? Is that where an easement comes in?
Yes, and an easement is a fascinating legal mechanism. It is a non-possessory right to use someone else's land for a specific purpose.
Non-possessory.
Yeah.
So they don't own it.
Right, it doesn't mean they own your dirt, but they own a legal right to cross it. A really common example is a utility company holding an easement to access power lines that run along the back edge of your property.
So I can't build a pool there.
Or a permanent shed, yeah, because the utility company has the legal right to bulldoze it to get to their wires if they need to.
That's wild. Okay, so we just talked about how a single overlooked zoning law or a hidden easement can totally ruin your plans.
Mm.
But honestly, the scariest part isn't the government, it's the ghosts of previous owners.
The ghosts.
Yeah. Like if I'm buying a house, how do I guarantee the person selling me the property actually has the legal right to sell it to me in the first place?
Oh, right. Well, that transitions us perfectly into the transaction pipeline because the transfer of ownership is this really meticulous sequence of legal checks and balances.
Right.
Tait breaks it down into preparation, title search, drafting the contract, and closing. And the specific answer to your question lies in the title search.
See, a title search sounds like the most boring administrative task imaginable. But reading the sources, it's actually closer to a real estate true crime investigation.
Yeah, it really is forensic historical work. A title search involves professionals digging through public records, county clerk archives, probate court filings, even marriage certificates going back decades.
Wow.
Yeah, they are trying to reconstruct the unbroken chain of ownership, verifying every single time the property changed hands.
So they're looking for a break in the chain. Like, I don't know, a forged deed from 1985.
Exactly, or an undisclosed heir from a previous owner's secret second family who suddenly has a legitimate legal claim to a percentage of the property you just paid full price for.
That is terrifying.
Or uncovering an old unpaid tax bill that a previous owner just ignored. Because in real estate, many debts attach to the property itself, not just the person who incurred them.
So if you skip a rigorous title search and buy that house, you are essentially buying someone else's legal nightmare. Okay, so assuming the title is clean, no secret families, we move to the contract itself. And the anatomy of a real estate contract boils down to 3 core requirements: offer and acceptance, legal competence, and consideration.
Right.
Competence is straightforward, I think.
Yeah.
Everyone signing is of legal age and sound mind. But consideration is a funny word in this context. It doesn't mean being thoughtful to the seller, right?
No, not at all. In contract law, consideration refers to the actual value being exchanged. For a contract to be legally binding, both parties must sacrifice something of value.
So the buyer gives up their money and the seller gives up their house.
Exactly. If there is no consideration, it is just a promise, and a promise is not a legally enforceable contract.
But the real superpower in these contracts according to Tait, is contingency clause.
Yeah.
These are essentially the built-in escape hatches,
They are crucial.
right? Like the inspection contingency, the financing contingency, the appraisal contingency. You are basically saying, I legally commit to buying this house if the roof isn't caving in, if the bank approves my loan, and if the appraiser agrees it's actually worth the price we agreed on.
There are critical defense mechanisms. Say you have a financing contingency and your bank suddenly denies your mortgage a week before closing. You can walk away from the deal and legally recover your initial deposit, which is known as earnest money.
So here is my deduction on this. If contingencies are my legal shield, shouldn't I just load up my contract with dozens of them to be totally safe? Like,
Yeah.
I'll buy the house if it passes inspection, if I get a promotion at work, if the stock market stays up, and if my astrologer says it's a good week.
Well, because you will look like a massive flight risk to the seller. Tait really emphasizes that real estate is a strategic balancing act. I mean, imagine you are selling your home and you receive 2 offers for $500,000.
Okay.
Offer A has 5 contingencies. Offer B only has 1, the inspection contingency.
Oh, I'm taking offer B every single time. Offer A looks like they are actively searching for an excuse to back out.
That is the psychology of the market. Sellers value certainty almost as much as they value the purchase price. So you have to leverage these terms to negotiate effectively.
Meaning you protect yourself on the major catastrophic risks like severe structural damage or a loan denial.
Right, but you keep the contract as clean as possible to remain competitive. And it is crucial to note that this entire contract must be in writing.
No handshake deals.
Exactly. The statute of frauds requires real estate transfers to be documented. A verbal agreement over a handshake to buy a house is legally meaningless.
Got it. Okay, so you have a clean contract, the title is clear of ghosts, and the contingencies are perfectly balanced. Now you have to actually fund this massive transfer of wealth.
And this is where the terminology usually puts people to sleep, but it is where the actual leverage of real estate lives, mortgages and liens.
The financial engine.
Right.
Let's start with the mechanics of a mortgage. You need to understand the 4 components, right? Principal, which is the raw amount of money you borrowed.
Correct.
Interest, which is the fee the bank charges you for the privilege of borrowing their money. The term, which is the lifespan of the loan, typically 15 or 30 years. And finally, the amortization schedule.
Amortization, yes.
I love the way this was broken down. Amortization is essentially a schedule of how your monthly payments are split between paying off the bank's interest and paying down your actual principal debt over time.
It's a sliding scale.
Yeah, I like to think of amortization as a seesaw.
A seesaw, how so?
Think about it. In year 1 of a 30-year mortgage, the interest side of the seesaw is weighed down heavily. Almost your entire monthly payment goes straight into the bank's pocket as interest profit.
And only a tiny sliver goes toward paying down the principal of the house.
Right. But as the years go by, the momentum slowly shifts. By year 20, your money is finally slamming down on the principal side, aggressively paying off the actual debt.
That is an excellent visual for how front-loaded mortgage interest really is. And, the predictability of that seesaw depends entirely on the type of loan you choose.
Fixed versus adjustable.
Exactly. A fixed-rate mortgage locks your interest percentage in for the entire 30-year term. Your payment for principal and interest never changes.
Which is safe.
Very safe. But an adjustable rate mortgage, or ARM, offers a lower introductory rate for the first few years, but then the interest rate unfreezes and fluctuates based on broader economic indexes.
Which is a huge gamble. If the economy shifts, your monthly payment could skyrocket overnight.
It happens all the time.
But what happens when the financial seesaw completely breaks? I want to talk about lens because the book draws a critical distinction between a voluntary lens and an involuntary lens.
That's a huge difference.
So what does this all mean, really? Like,
Yeah.
I willingly sign a mortgage. That's a voluntary lens. I offer the house as collateral. But an involuntary lens, how does a guy who fixed my roof suddenly hijack the ownership of my house?
It comes back to the concept we discussed earlier. The debt attaches to the dirt, not just the person.
It's the dirt, right?
If you hire a contractor to put a new roof on your house and then you refuse to pay them, they can file what is called a mechanics lien against your property.
Because they improved it.
Exactly. The law recognizes that their labor and materials physically improved the value of your asset, so they are legally entitled to a slice of that asset until they are compensated.
The way I see it, an involuntary lien is like a financial boot on your car. You cannot drive that transaction forward You can't sell the house, and you can't refinance your mortgage until you pay the toll to unlock the title and get the boot taken off.
Or worse, if the lien is large enough, like an unpaid property tax lien from the government, they can literally force the sale of your home through foreclosure just to satisfy the debt.
And the fastest way to trigger these financial disasters is by cutting corners, especially when we transition from simply owning a property to renting it out. Because the landlord-tenant dynamic is a notoriously delicate balance of power.
Oh, it is heavily regulated for a reason. The tenant has a fundamental legal right to habitability, meaning the landlord must provide a safe, structurally sound environment with running water and heat.
Basic human needs.
Right. They also have a right to privacy. A landlord cannot just barge in whenever they feel like it. Conversely, the landlord has the right to receive timely rent payments, and if the contract is breached, the right to reclaim the property through eviction.
Tait points out a fascinating psychological trap here. People will spend 60 days obsessing over the exact shade of gray paint for the kitchen cabinets of their rental property.
Oh, definitely.
But they won't spend 60 seconds reading the eviction laws of their specific state.
Because they treat landlording as a passive income stream, when in reality, it is a heavily regulated customer service business.
Wow, yeah.
Customer service. Landlords routinely make the catastrophic mistake of failing to screen tenants properly. They skip the deep background and credit checks to save a few days of vacancy and end up with a tenant who stops paying.
And then what?
Then they discover that the legal eviction process can take months, costing them thousands in lost rent and legal fees.
But tenants make equally devastating procedural errors. Right. They skip the move-in inspection. They don't take photos or document the scuffed floors and the broken blinds the day they get the keys.
And a year later, they lose their entire security deposit because they have zero proof that the damage was already there. Both sides suffer when they ignore the operational mechanics of the law.
So you can do the title search perfectly, balance the contingencies, screen the tenants, and still end up in a nightmare.
Because ultimately, we are dealing with human beings, large sums of money, and highly emotional physical spaces. Conflict is inevitable.
Which brings us to the crucial question of dispute resolution. When the contract breaks down, what are our options? Because going straight to a judge seems like dropping a nuclear bomb on a disagreement.
And it usually is. Tait outlines 3 ascending tiers of resolution: mediation, arbitration, and litigation.
Okay, let's walk through those.
So the first, mediation, is highly collaborative. You bring in a neutral third party not to make a ruling, but to facilitate a compromise between you and the other party.
It's essentially guided negotiation.
Well, actually, let me back up. It goes further than just negotiation. It is specifically designed to preserve relationships. If you are arguing with a tenant who still lives in your building or a neighbor you share a driveway with, you don't want to destroy the relationship entirely.
That makes sense. Plus, it's cost-effective and private. But if mediation fails, we step up to arbitration.
Right. Arbitration shifts the power dynamic. You hire an expert arbitrator, often someone with deep real estate or construction law experience.
Like a private judge.
Sort of. They review the evidence from both sides and make a binding decision. It functions like a streamlined private court. It is significantly faster than a public trial, but you do surrender your control over the final outcome.
And finally, we have litigation. The public courtroom, the judge, the discovery process.
The absolute last resort. Litigation is incredibly expensive. The public record exposes your private business dealings, and a complex real estate case can drag on for literally years.
Yeah, nobody wants that.
Yeah.
You only pull the trigger on litigation when the financial stakes are massive and all other communication has completely broken down.
Absolutely.
But here's where it gets, really interesting. Look at where we are heading in the near future. The final sections of the book get into the high-tech frontier of real estate law.
Blockchain, artificial intelligence, virtual reality.
Right. If a blockchain can create a self-executing smart contract, meaning the code verifies the title is perfectly clean and the millisecond a buyer's funds clear, the digital ledger automatically transfers the deed without a single human middleman. Doesn't that make things like arbitration completely obsolete?
That's a nice thought.
I mean, if the tech removes the friction, what is left to fight about?
Well, if we connect this to the bigger picture, that is really the utopian view of technology. But it misses a fundamental reality.
Which is?
Technology changes the tools we use to transact, but it does not change human nature.
The The blockchain can't stop my neighbor from intentionally building a fence 2 feet over my property line.
Precisely. A smart contract might eliminate administrative title fraud, and an AI might be able to draft a flawless commercial lease in 10 seconds. But AI cannot solve a tenant who simply refuses to vacate at the end of their lease.
Right.
It cannot solve a seller who deliberately hid the fact that the basement floods every spring. The human element of malice, negligence, and miscommunication will always require a legal framework to resolve.
So the disputes don't disappear, they just evolve.
They do, and in many cases, new societal trends create entirely new categories of disputes. Look at the massive legal shift towards sustainability and climate resilience that Tait highlights.
Oh, sure.
Governments are rapidly pushing green building standards like LE certification and mandating strict floodplain management rules.
Right, so if a city suddenly passes a zoning ordinance stating that all rental properties must be retrofitted with solar panels and high-efficiency insulation by 2030, the sheer cost of compliance is going to spark chaos.
That is the new frontier of litigation right there.
Yeah.
Landlords are going to fight municipalities over the unconstitutional burden of those costs, and tenants are going to fight landlords over the massive rent increases being used to fund the retrofits.
Wow.
So the mechanisms of the disputes will shift toward environmental compliance, but the need for clear, enforceable real estate law remains absolutely vital.
That is wild to think about. It really reframes the entire topic for me. I mean, real estate law isn't just a dusty textbook of jargon to memorize for an exam.
Not at all.
As we've explored today, it is the foundational operating system of wealth building.
It is the invisible architecture that supports every physical building you see.
Understanding this architecture allows you to prevent devastating errors, like ignoring an easement, skipping a rigorous title search, or misunderstanding how your mortgage amortization actually works.
Yeah.
But more than just playing defense, knowing the rules of the game empowers you to structure deals creatively and seize market opportunities with complete confidence.
And we have to give immense credit to Willem Tait's approach here. He manages to take a subject that is notoriously dense and makes it remarkably practical.
Yeah, he really focuses on the operational mechanics, like what actually happens on the ground during a transaction, rather than just abstract legal theory.
It is a masterclass in seeing the matrix of the property world.
It really is. And that brings us right back to where we started. That feeling of holding the keys to your new kingdom. It might not be a kingdom of absolute unchecked power.
No, you might not be legally allowed to build that moat.
Right. And you might have to check the zoning laws before you paint the front door neon pink. But when you understand the law, it becomes a kingdom you can actively protect and predictably grow.
Which leaves us with a final, rather pressing thought to consider as we wrap up today. Well, as climate change accelerates, governments are going to be forced to mandate stricter, more aggressive environmental regulations on private land.
Inevitably.
Right. So this raises a profound question for you to ponder. In the near future, where exactly will the law draw the line between your absolute fee simple right to use your property however you see fit and the broader community's right to survive?
Oof, that is a heavy one to chew on. The line between the dirt in your backyard and the survival of the neighborhood. Well, thank you so much for joining us on this deep dive into the hidden wires of the real estate world. Keep exploring, keep asking the hard questions, and we'll catch you next time.